Welcome to the Justice Room. Your life, your rights, your options. Experience and learn from discussions with legal professionals and other experts about the law, its challenges, and how it could affect you. Here at the Justice Room. Welcome to the Justice Room. Where would the children go? Do you have the right to say, I want my children to go with this next of kin, or do they say where the child goes?
Well, investigator who was at the scene should, while interviewing the parent, ask them if they have an available relative that can take the child or children. If that person does list a person who's, let's say in the state of Florida, if they're a local person, that investigator can literally that night do an emergency background check and place the child or children with a relative.
Now, what kind of background check or requirements are we talking about? And I mean, I want to stay a little bit more on topic here, but if the parents are having a child removed and the person that they'd like to have the child placed with has a criminal felony charge against them, would that child be able to go with that person?
Depending on the type of case and how long ago it was. If it was a felony from 20 years ago, the investigator who goes out to the prospective placement's home could very well review that with their supervisor, and they could determine that, hey, this is no reason to keep a child out of a relative's home. It could be a check fraud charge from 20 years ago. Who knows?
But now, can the child? You're talking the way that it's sounding is like as if all this happens pretty quick.
Well, it does sometimes when we're speaking of removals. If a person lists a relative, sometimes that night they can do the background check, go to the home, have the child taken to that home. Sometimes that does not happen. You end up at the shelter hearing with the judge, and at that point the judge has to determine, once again, placement. Okay,
now so they don't go with a family member. They're removed. Where do they go?
Foster care.
Okay, so now they're in foster care for possibly just that evening, possibly longer. You go to the shelter hearing. Now what? You're the parent. You're at the shelter hearing. What do you expect?
Well, the shelter hearings here in Orange County are held over on Michigan Street at the juvenile courthouse. In the state of Florida, Dependency court is held through juvenile court. When the parent gets to court, they will be, of course, allowed to apply for a court-appointed attorney, because all parents have the right to be represented by counsel at the shelter hearing, and if they cannot afford counsel, to be appointed counsel.
But what exactly is the shelter hearing? What is it meant to do?
The shelter hearing is meant for the court to review the facts in the petition and to determine if there is probable cause for shelter, meaning similar to a criminal case. When a person is arrested out on the street, that's similar to the removal of the child. A criminal person goes to first appearance, parents and dependency court go to a shelter hearing, and the court says, okay, there's probable cause to shelter based upon the facts in the petition.
Now, let me stop you for another second here, because the parents are going to a shelter hearing similar to that of what you're referring to as a first appearance in a criminal court.
Yes.
Okay. So first appearance is criminal court, shelter hearing is dependency court.
Yes.
So you're going to the shelter hearing. Do the parents have a copy of the petition at this point?
Yes, they are served a copy of the petition when they do come to court to read the allegations that are against them. The
day that they arrive at court, or before that? Do they have a chance to read it that night?
No, because when the investigator's out at the scene, they don't have all of the allegations just yet. They type it up after they've made contact with the family. So the parent will not get that petition until the next day. Okay,
so then they're probably coming to the shelter hearing. They're being provided a copy of the petition.
Yes.
And how soon do they have to wait to have attorney representation, whether it be court-appointed or private counsel?
Well, if that person qualifies for court-appointed attorney, they will get an attorney that day at court when they appear for shelter.
Is that pretty typical across the entire U.S., or is that something that's just Florida-based?
Well, I would have to say my knowledge is more so in Florida, so I would have to say in Florida that's the typical.
Okay, so if you're in another state outside of the state of Florida, you probably should do a little bit more research or diligence on that, and make. But for the most part, that may be the same.
Yes,
but we're not sure.
I would assume I know that they do have court-appointed attorneys in the other states, having dealt with other attorneys who've worked in the system, because the United States Supreme Court has found that parenting is a fundamental right that should not have unnecessary state intervention. So I'm sure the structures are pretty much the same, just different statutes, different states.
Okay, so now you appear at the shelter hearing, and the courts make the determination of court-appointed counsel, private counsel, all that's done, and what's the next step from there? Can you get your children back that day?
A person could get their child back that day if they contest probable cause, meaning that they tell the judge that day that they want to have a hearing on whether the allegations amount to probable cause that the children are at imminent risk. And there have been cases where the court did not find probable cause and has sent children back home.
Okay, so what happens after the shelter hearing? If the child gets sent back home, is the case in essence over, or are there other steps that have to be followed?
Sometimes the court will give the department leeway to file a petition for dependency in cases where there has been a shelter. The court will say, okay, I find probable cause, however, I am going to return the children home for these reasons.
Okay.
If the court finds probable cause, then the next step, of course, for DCF is to file a petition for dependency.
Now, DCF has their own set of attorneys that represent them, I would imagine, at the shelter hearings.
Yes, the Department of Children and Families attorneys do represent the state with regard to removal of children.